one of the things that strikes me, Chair, that has struck me about the CETA presentations is the openness of everybody to being frank with the committee. If there are divisions, those divisions always come through clearly, and I think that's a good thing, because then at least we can see what the problems are and work out a way we are better able to work a way around them. Just have a few questions. For me, one of the issues, can't remember whether it was the minister or the board chair that mentioned this, but it's the proposed suspension of the AMD. I just wondered to myself, I mean, we know that there are conditions that are needed, or suspensions, there are conditions for suspensions. What would those conditions be, as opposed to maybe if the appointment was irregular, deal with the irregularities and then either fire or correct in whatever way without a suspension? What justifies a suspension in this case? That's the one. The other question is for anyone from the interim board, if they could please tell us, why did they find it necessary to support the applications of the minister in regard to the issue of the board dismissals, to the point where even individually they supported these applications? Why would they do that? The chairperson made the point to say this was probably the clearest indication, and may even have been the kickoff point for the conflict that we currently see in the board now. And then I was interested to see all these new subcommittees, but the question in my mind was, this board is a reinstated board. It was the board that was running the CETA before. So what was happening before? What was there before? And what kind of motivated the fresh eyes in terms of now we are going to change everything, but actually this is an organization we were driving before anyway. How did that come about? And then the chairperson also said there were two orders of the court. One was to reinstate the old board. The second was to suspend the appointment of the interim board. However, we see the interim board very much present. So what is the status of that order to suspend the appointment of the interim board? I would also like, there was a mention of it, it was a passing mention by the chair mentioning the company secretary. And I know that there was an issue about a company secretary who'd been dismissed. There was just controversy around that. Can we please have clarity? What is the status of the company secretary at this point? Who is the company secretary at this point? And then Director Peterson mentions, the Honorable Mani has spoken to this. I was also just keen to know about the justification, perhaps this would be from the chair, of separating risk and audit. And the other thing that I wonder about, Chair, is what are the communication channels within the board, between members of the board? Because things just seem to happen without... At what point do board members act individually on both sides of the board? And at what point do they act as a collective? Or at what point do they at least interact with one another in regard to matters to do with the organization? Because at the end of the day, they're not serving their own personal interests, which I think is part of the point that the Honorable Mani was making, but they are meant to collectively and individually work for the good of the organization. Director Vuma, I agree with her that what is the point of the organization seems to come last. The CETA is the technological edge of government, but at the end of the day, even her presentation came last. But it couldn't have been done any other way, because the other issues are predominating, are sort of predominant at this point in time. So for me, it's just an illustration of the cancer maybe that exists within the organization. But I just thought my question for her was, is there a forum of government department CIOs where they can then talk together about delivering these technological advances and technological projects that she says they have the capacity to? I think that such a forum would help align technologies, it would help with economies of scale, and it would help to speed up implementation, but also have one government process as opposed to SAPS doing its own thing, Home Affairs its own thing. And then my final question is to Director Geise, who proposes administration for the for SETA, of SETA. I believe he was involved in a prior administration of the organization, and look where we are now. So what difference would, or what leads Director Geise to believe that administration now would make a difference in the organization? I thank you, Chair.
Good morning, Chairperson, colleagues, Minister, Deputy Ministers. Chair, where does one start? I think, let me start with the urgent matter, and perhaps this is directly to the Minister. We have heard today that the term of the board is expiring as of January, and the board has told us today that they are planning on an AGM in 2025, early 2025 January. So, an AGM takes place after a lot of planning. What planning is happening with the board that is on its way out, for all intents and purposes? Will the AGM happen? We are already sitting where the reports are not coming through. We have heard that the memorandum of incorporation does not speak to the situation of SETA at this point. And what guarantees do South Africans have that the current board, which is in limbo, is working towards empowering SETA to be a stronger organization? Because what we are hearing today is that SETA is fragmented. We are hearing that there is serious differences within the board, between the board and the executive. And perhaps this leads me to my question to DM Gungubele, who is the immediate past minister. Does he believe he did enough in his tenure as minister? Because listening from what we are hearing today, these things are historic, and he would then have the historic knowledge and the institutional memory. Does he think enough was done? What else could have been done to prevent us to getting to this point? And also to the former minister, and Honorable Vilakazi has asked, but I want to ask it differently. How did we get to a point where the ministerial task team are also cited as respondents to the court case? And what was his position on that? Because you end up with 12 respondents in the court case, and those, some of them being part of the MTT. How did we get to that point where you have an interim board fighting against the board? And I lack the vocabulary to speak to that. To the minister, we are sitting here with Part B of the SCA ruling not implemented.
Historic. I wanted to check what's the question behind that.
Oh.
Sorry, Honorable Botlani, did you want to repeat it? Let me tell you just quickly. The questions were, did the former minister, does he think that he did enough, given the fact that he'd have the historic knowledge and institutional memory? And then also, how did the MTT end up as respondents to the court case? Yeah? Thank you.
Well captured, Chairperson. Thank you so much. And to the minister, we are sitting with the board again in limbo on the Part B of the court ruling. Where are you? Where are we what are your plans on that? Because if I understood Chairperson Musidi, they also do not know. There was some sort of agreement, but I don't think I clearly understood what their position is, and where does that leave this? I think it's really concerning that we are hearing that SITA is spending so much money, this is from the HR chair, on unfair labor practices. If you're going to have a workforce of 3,500 people, which is not really a lot if you ask me, but you are going to spend so much time in the courts, in the CCMA, trying to defend labor practices, then something is not right. What plans are there to ensure that we put a stop to this back and forths and SITA being taken to task by employees? Oh, the audit committee, how do they then operate if they do not have the terms of reference? What informs their outputs? How do they measure the work that they do outside having terms of reference? And what is the response of the board to the allegations that they are involved in procurement processes? What is the response? And I don't want to also get into the Musidi board, Pillay board, hybrid board, because already that speaks to how fragmented the board is. If they are going to be identifying as this board and that board and the other board, that's an issue. And Ujobe has spoken to the issue of vetting. Can we get more on that? Are there specific people who have refused to be vetted? Because Chairperson came back and said, oh, there was another thing, something else was done that I don't know whether it replaces the vetting, so I don't want to misquote her. Can we just get clarity on that? I fully agree with Miss Nodita Peterson, who says on the 1.2 billion rand Western Cape Department of Education, we must follow the money, and indeed we must follow the relationships. Chair, Director Pillay speaks about heading the social and ethics portfolio, and he literally stood there and told us they have done nothing. What stops them from doing anything? If we are talking about a green economy, if we are talking about sustainable business practices, is it an issue of business, of not having a budget? What stops them from being able to speak in this meeting today about what they have achieved, and what plans do they have to ensure that the next time we hear from them, they've got substantial things to report on? Chairperson, I go back and I go back to my note says we have a DG who was the acting DG at the time. We have Ubabu Shelembe, who is the DDG. I would love to hear their voices. I'm sure they have something they can say to this portfolio committee about the situation that SITA finds itself. They are the oversight of SITA. What can they tell this committee that we have not heard? What can they tell this committee about what their interventions have been? And why did it fail? Because sitting where we are sitting, whatever intervention has been brought through has failed. That's why we are sitting with a description of 3 different boards. I'm quite an optimistic person, and I am very reluctant to use the word relations are irreconcilable. But if Honorable Manyi says mabahambe, and we are left with a January, December, and this was supported by Director Keise, Minister, what are you going to do? Can we get an indication of what Minister plans to do, at least by the time we leave here, and South Africans that are also watching to say, what is going to be done? And I'm sure Minister needs time to apply his mind, but can he just speak to that? Or the question I have is, who is the current company secretary? Because we've seen documents about the dismissal of Ms. Laka. And I'm not sure who can speak to that. And Minister spoke to the issue of PSC could he just, I know he was pressed for time as he was making his opening remarks. Can he speak to us a bit more about what those plans are? Ke a leboga.
Thank you, Honorable Bodlane. Honorable Chauke Adonis?
Thank you so much, Chairperson, and greetings to the Minister and the Deputy Minister and honourable members of the Portfolio Committee and officials who have joined us from CETA as well and supporting staff. Chairperson, I think I've been greatly covered by my colleagues, but one raises some concerns in terms of the functionality of the board and how fragmented they are. There are some eyebrow-raising questions that arise in terms of the presentation. And I think we are a portfolio committee that is very solution driven. And with the presentations coming from the subcommittees, one has identified that the challenges persist and they are there. But what we are not getting are what are some of the solutions that are being provided by the board members themselves. Because we must be able to come out of this particular sitting having identified the challenges, but also having been guided by the board members as to how we can mitigate and intervene to really make sure that we address the systematic challenges that they've identified. Secondly, Chairperson, when it comes to the order of presentation, and this was said about by my colleagues as well, in terms of the organogram to be followed in the hierarchy or the structural presentation in terms of the board as a non-executive board, I think it was a very important understanding the functionality of CETA to really have the IT element of it being the first part of the presentation and really taking us through the operational elements of the CETA, but also in terms of what are the forward or progressive ways in which they are looking to really innovatively provide more solutions in bettering the operations of the CETA. Then, Chairperson, another thing that one also wants to really find clarity on, and I think is the element of the non-executive and executive board members in terms of the accountability. And one would have a clear understanding in terms of reference and understanding in terms of organograms, who comes before who should be reporting to who. But I think in the presentations that were made now, one is slightly confused and concerned as to what that structurally looks like and also in practicality. And I think this is where also as the Department of Communications and Digital Transformation needs to really play quite an integral, but also as the Portfolio Committee, oversight role. And the responsibility and burden should also be upon ourselves because this is a public and national institution that's supposed to be servicing our people. And therefore, we cannot wait for audit outcomes and findings to first be presented before we start addressing the systematic challenges that we're able to really get as they start. Chairperson, another thing that one wants to get, and I think Honorable Manye also mentioned, and this would be for the board to go under administration or to be released, and perhaps one would want to get an insight and a view from the executives. What are their findings? What are their views? And how have they found in terms of mitigating and having intervention to address the challenges that persist? Are they finding that within these 2 months that are left, something can be done? Or do they feel that there is no value for what it is that the board currently in monetary and also in resource is being plowed into them? Because one must understand that we are utilizing state resources. These are taxpayers' resources. And when you have a board that is this dysfunctional, according to how they've presented themselves, it raises concerns, and we must be able to address it and either put them on under administration while we are looking for ways in which we can intervene and address. And then, also, sorry, Chairperson, one also just wanted to find out, when they were suspended, was it paid suspension or unpaid? Because again, taxpayers' resources that are being put into these suspensions that are on and off. So we need clarity on that. And then I think, Chairperson, I think this was also mentioned by my fellow colleague, was to say what prompted the implementation of the subcommittee And then also, what is the objective of these particular subcommittees? Lastly, Chairperson, it would be, what are the measuring, monitoring, and evaluations tools that are being utilized? What is the formula that the portfolio committee would be able to really look at and evaluate in terms of the performance of the executive and non-executive board members? But also, what is the DG? I think also the DG needs to just give us in terms of his or her proximity and the ability to really have an oversight on the operations and the functionality of the structures, and also some of the limitations that they are having in terms of how far and in terms of the reach they are able to get in terms of addressing the challenges that they are able to foresee. But overall, thank you so much, Chairperson, for the presentations.
Thank you, Honorable Chauke Adonis. Honorable Subrathi.
Thank you, Chairperson, and thank you to the Chairperson of the CETA board for the presentation. Chairperson, I'm the last of the honorable members that has the opportunity to speak here, and I think the sentiments of my colleagues, I share in it, and my biggest nightmare, Chairperson, is that if the board is so divided and so fragmented, then what must be the situation on the ground with the staff and the executive team? Chairperson, as I listened to what appears to be a total breakdown in the board, I am reminded of an analogy of a family in which the parents are in such a squabbling and toxic relationship, and the profound impact it has on the well-being of the children. And that haunted me as I sat here. Because, Chairperson, we are here as a portfolio committee to fulfill our constitutional mandate to ensure that South Africa gets connected. And CETA is the bedrock of achieving that vision. And we have a responsibility, Chairperson, to provide guidance. Chairperson, I have a series of 10 critical questions which I would cover. But before that, Chairperson, I would think I'm quite perturbed that there was no proper reasons given by the other members of the board of not being here, given the critical importance of us being able to engage. I want that to be recorded. Chairperson, we just got off the back of, as a portfolio committee, very successfully within 4 months, recommending 6 candidates for the ICASA appointment of ICASA councillors. And one of the aspects we looked at, Chairperson, and you were there and you led us, was the issue of continuity. We looked at the previous members who served on previous ICASA board, and we said, what wisdom is there that we can bring from them into the candidates we recommend? Chairperson, I think if we have to do that for CETA, we will face a different outcome. Chairperson, once we have board members here, I will be keen to know from them, from the board members, because they had been entrusted to run CETA. How do they see the way forward? That's the first question I'd like to know from the members, because this is a truth. We're speaking truth to power here, and I'd like to know from them. Secondly, is they had a responsibility to empower the executives, the staff, to ensure they mentor and train. Your tenure is coming up on the 31st of January. Are you satisfied and are you comfortable and are you happy to the board that you have fulfilled your mandate to leave behind a team that can continue to operate and meet the mandate of CETA? Chairperson, perhaps this is a question for former Minister of CDT, DM Mondley. And a question of reflection is, where did we drop the ball? Where did we drop the ball? Chairperson, we cannot isolate the fact that what happened in the tender in Western Cape Education Department, it is a case study. And it's actually a manifestation of the systemic problems and challenges that we're witnessing here at ICASA. But I think it would be important for us to interrogate and understand that why has the board been so loath to either implement what the CDH had either implement or go to court and find it to be inappropriate. But you cannot be sitting in the middle. Why have they dragged their feet? Chairperson, if I can go to some specific questions, for whatever it is worth, I'm going to ask these questions. To the board, can you explain, this is regarding accountability for performance, can you explain the specific measures the board has taken to address the allegations of CETA failing in its mandate? And I would like to know, Chairperson, what are the accountability mechanisms that are in place for board members and for executives? And the second of my questions would be, how does this current governance structure of the board ensure effective oversight over CETA's operations, and what changes, if any, are being considered to improve its functionality? Chairperson, I won't go into any of my specific details because I think the critical issue for us, Chairperson, coming out of this is to really decide what happens from the 1st of February 2025 when CETA board of directors tenure ends. What do we do post when their period of service ends? Thank you so much, Chairperson.
Thank you very much. Thank you, honorable members. Maybe let me start exactly where you ended, Honorable Subrathi. I avoided phoning the minister about this visit. And the reason for that is because we have been dealing with CETA for a while. As a committee, we had recently sent a letter to the minister when we received the representations from PSA as well as reports of the precautionary suspension of the MD. The minister requested time to deal with the matter. It was 21 days to be specific, which we felt was reasonable. Now, less than 3 days after he had requested that intervention, we are here. And that speaks to the urgency of the issues at CETA. We could have said, no, Minister, take your 21 days, we'll hear, but then by the time we come here 21 days later, what would have happened in this institution? And why I'm starting there is to explain, in my head at least, which then you may comment on, that since the board came back, there seems to be a lot of decisions that are taken in a very hurried manner, and you ask yourself, but why this rush, right? And also, would you not expect this board to be cautious, given the fact that their term is coming to an end? I'll make an example which then requires direct answers. When the board came back, and I listened intently to the chairperson of HR trying to explain this, when the board came back, one of the first things that they did was to lift the suspensions of the company secretary and the CPO. When the chair of HR is speaking, Remcom, she says, because the LRA as well as the MOI say within 60 days, 90 days respectively, whichever the case is, you must have concluded. However, you don't have to wait for the employee to be there. Now my question is, why didn't you then just proceed? Why didn't you proceed if you didn't have to wait? Why did you take a decision rather to uplift the suspensions? And also, one of the members asked you the question that if you are so unhappy with this report, why didn't you take it to court? If you think that you should not be acting on the CDH report. And I appreciate the fact that what is coming out very clearly is that this report actually seems to be the root of all evil, perhaps even building on all evil within this institution. So after that, we are then given information that says the MD was then instructed to extend the contract of the CPO, which if I stand to be corrected, that falls outside of the authority of the board. And Minister, I'm giving this background to say, not that we did not respect you wanting to have some time with these issues, but if all of these decisions are taken in such a big rush, where will we be come 24th of January 2025? And hence then the need for us to intervene. I also really want to know why this board did not see it fit to refer these matters for further investigation coming out of the CDH report, whether to the SIU, whether to the Hawks, or, again, I repeat my question, take the report on review. You're wasting state money, seeking legal opinions, which I'm not sure why you're doing that. Now, one of the board members, when they speak to the fact that, I want to find the exact words that she used. I think it was Director Peterson, where she says, you don't have the ability to get to the bottom of the matter because they are conflicted and implicated. So I don't know why you would want to take us back and forth on a report where the board itself knows that it is conflicted and implicated. So we're looking for some direct answers to that. Let me just go, so that was in way background. I've got one or two questions. Role clarification, I agree with Honorable Mine. I looked at the structure of the board and I thought, he executive mostly. And I was asking the minister, Kanti, how many board members do you have? Because literally, it seems like every board member chairs something, which then makes me wonder. So they chair, they report to themselves, and what on earth is the executive doing in that situation? Because it means that every single executive director in this organization or executive management has a board member above them, asking them, what are you doing? You know, I don't want to repeat the issues that Honorable Manya raised, but for me, it's literally a duplication of the executive structure. I'm keen to find out from the minister the settlement agreement that has been proposed by the board, whether he's had a chance to consider it, what his views are, and what that settlement agreement entails. Again, we've had reports of demands being made by the board of settlement for either the time that was lost or the fees that was lost. So we just want to understand how far the minister is. And again, to Honorable Manyi's point, I would assume that the minister within that settlement agreement also can propose a settlement of his own to ensure that as soon as possible we're able to speedily resolve and, if necessary, cut ties with this board. It's been very distressing to sit here and listen to a board that says nothing about strategy. Absolutely nothing about strategy, where they are leading this organization. And while I agree that it's important that we get a sense of how the board functions, and also given some of the recent challenges, I don't understand how a board can speak and not at least give us a sense of direction. Whether we would have been specific or not, I think it stands to reason that that is what you are doing. Yeah, let me stop there. I think the members have made the point about the dysfunctionality, the lack of attention to what is actually important in this organization, the call that we must follow the money, and so forth. So, Minister, I'm going to hand over to you for your remarks, followed by the DM, the DG, and then I will then hand over to the board. Thank you, sir.
Lest we be accused of blurring the lines between the executive and the legislature. But just to deal specifically with the questions that were raised, directly to me, I think one of the things that and I just need to get confirmation from the team. So one of the things that we have initiated in anticipation of the fact that the natural period for the board ends in February is to trigger the process for the advertisement for the board that will then succeed this post that time. And this week we finalized, the ad, and it should be going out probably in the next few weeks. So that ideally we don't, and that's the ministry's view, don't want to be in a situation where by the end of the term of this board, there is a vacuum in terms of your leadership. And we are mindful that that advertisement and doing the interviews and finalizing that is likely to take place towards early January, and that you've got very little time to do that. So that's ideally what we want to do based on the volume of applications and all the other related things that are associated with an application. But I think the two critical questions that were asked, one by Honorable Manyi, and also the Chair's concluding remarks with regards to, in these very few weeks left for this board, what becomes the right thing to do? And that is the question that we're also grappling with, taking into consideration that there is the unresolved issue of the legal fees, which the settlement indicated that it will have to cover those, and we haven't reached agreement on that as yet with regard to that settlement. And I take into consideration what the portfolio committee says, much more clearly expressed by Honorable Manyi. I think the most important thing is, even in what we do in closing this chapter about the life tenure of this board, we have to make sure that we act in the right way. We have to make sure that we protect the institution and the ministry's actions so that we do the right thing in the right way. And that's what we are grappling with. I think, based on the sentiment that's emerging here, some would argue that the easiest thing would be to dissolve the board, right? And then face the consequences of that dissolution just a few weeks before their term expires. Honorable Adonis also raises a key thing that, what do you do in between then? Because there are state resources at play, whether you keep the board as is, dissolve it, or whether you pursue a settlement on this. There is no outcome about this that's going to be ideal. That is the bottom line. And that's something that we're grappling with, and we hope that we'll be able to indicate to community it won't be today in this session, because I think there is a recognition that making that determination requires due handle. But those are the choices, and those are the choices that confront us, that we have to live with. Do you dissolve this board now, 7 weeks, 6 weeks before the end of its tenure, and live with the consequences that come with it? And is prolonging the stay of this board for that, until the end of its term also the right thing to do, because of these growing concerns? Because it could be seen and misinterpreted as condoning this state of events that are currently at play happening. So I just want to put those to the portfolio committee, that those are the considerations at play. With regards to the status of the settlement, I'm going to ask our head of legal just to give an update in terms of where it is now and what are the considerations with that. But I thought it's necessary to put those facts and those options so that even the actions that may happen after this process, the portfolio committee is mindful of the variables that are at play and the options that we have to grapple with in making the determination about the future of the board in the next few weeks and how we handle that question. Because even in doing so, the key thing is this institution, the difficulties that are there, are not only at the top level. It is deep-rooted. It is severely deep-rooted, and any intervention that might, address the issues that are happening at the apex of leadership there alone won't resolve the deep-rooted problems that this institution is facing. And that's why our intention is to get far much deeper into that, so that we can improve the environment in here, so that even for those that work here daily, are encouraged and motivated to come and work here. I don't think any of us enjoy the exchanges that happen in here, because they show an institution that, based on the relationships that exist now, is deeply broken. That's the honesty. And different individuals and all of us may bear some responsibility at one stage. And I think the key thing again comes down to when we integrated the committee, the board, the nobility would hope that there is continuity, would hope that there is balance in the reinstatement of the board, and that individuals can be able to transcend whatever personal agendas that may have been there to do the fulfillment of the work that is at play here. And these developments are disheartening, because that hasn't been fulfilled, largely because vested interest or natural conflict, because different teams at any given time might not be seeing eye to eye. But our commitment is, we want to get to a period where there wouldn't be a vacuum of leadership in this organization and in this institution. And that's something that we want to handle in between now. We'll be making sure that the advert for calls for nominations for the new board goes out, and that we can expedite that process. If that process can be expedited before the end of this term, there has to be an interim relief in that period. And that is the one option that is also in play. Thank you, Chair.
Thanks, Minister. Can we just get you looked that way, the head of legal, just to conclude the Minister's response?
Thank you very much, Chairperson. Good afternoon. Yeah, okay, thank you, DG. My name is Tsegofatso Kgabiang. Yeah, as this mentioned, I'm the head of legal. Thank you, Chairperson, Minister, members, honorable members, all protocol observed, and good afternoon. Yeah, just to conclude on that part, there is already a decision that the minister made that we are going to settle this matter. You will know that, Chairperson, this matter was divided into two. It was part A and part B. The minister said, no, after SCA decision, we are not proceeding. We are going to settle this matter. I am in contact with the attorney that is representing the board. We are now agreeing on the terms of settlement. Yeah, one of the conditions, as part of the settlement is that, which is an opinion that we obtain, is that we are going to pay them for those board fees that they should have got them had they not been removed. And yeah, that's one of the terms, and we are just only stuck on the issue of legal fees. So we are negotiating with CETA to either pay the legal fees or ourselves. I mean, the legal fees we are agreeing on scale. I think we are stuck on whether it should be attorney and client or party and party, but it's about a taxation. But what I confirm, my minister instructed me that I should make sure that I settle the matter. He said, actually, I'm not going to leave unless I settle this matter. So I can confirm that by next week, or the latest Monday, Tuesday, we would be settling the matter, making it an order of court. That will be the end of it. Thank you very much. You mean the financial cost? Okay. Okay. Yeah. Let me put it like this. The legal fees that they paid the applicants, the board members, to their attorney is 1.3 million. But what is going to happen if we pay the legal fees at an attorney and client scale is going to be 1.3 million. But because we are going to pay at the scale called party scale, it means they have to go to the state attorney to tax those costs so that they can pay for what was necessary and reasonable. It may go down from 1.3, you know, after taxation and the master they approve, but it's around that region. And the cost for for board members, for all, because of all board members are going to be paid. Not only the 3, but those that also resigned because of the letters for disciplinary process. From the report that we obtained, it's in the region of 2 million. 2 million, I think around 2 million, 2.1, then it will be divided amongst all those board members. Thank you.
Any consequences for the minister that caused that mess? Thank you very much, Chair. I just want to go and look at the question freshly raised by the member. Do we think we did enough? And the other question was, how was MTT, how did they become respondents? I think in terms of my record, I don't have a record of them being respondents, but I could have missed. Although I know legally, most of the time, applicants, when they are fighting, they would list whoever is in the system who is of particular important role as a respondent. But you must remember, the respondents are not listed by the defendant. They are always listed by the applicants. But in terms of my records, I don't remember MTT becoming respondents. But I just want to, if the chair can so allow me, to draw some picture. On my arrival as a minister, that is March, I was doing rounds, meet and greet. In one of the meet and greets, SETA was part of the meet and greet. In that meeting, an MD was introduced, a new MD. I was very excited because he came across as quite very brilliant. And I loved the guy. But later, I got a submission to approve his appointment. That's the sequence of issues. I got a submission to approve his appointment. Immediately, a question rose in my mind. How do I get introduced to an appointed MD who later I have to approve his what to call? The records are there, his appointment. Immediately, I asked the legal guys. Skuvazo is one of them, to check what exactly this thing. It was revealed to me proper processes were not followed for cabinet what to call approval. Now, we had a dilemma. You look at the track record of this chap, he's young and brilliant. Do you want to be merely technical and allow somebody like this to get out of the system? I was reluctant to do that. To demonstrate that I was reluctant to do that, we prepared a memo for cabinet to condone, in spite of all that. But we had to tell the cabinet where the process defects were, right? We even sought legal opinion in that regard. But what is interesting is that in our records, you will find that even the board itself did seek a legal opinion with regard to the proceduralness of that appointment. And they had an opinion that said it was unprocedural, their own legal opinion. So you will get that, you can submit those records, they are there. So because we didn't want to lose this young chap, we went to cabinet. We presented this to the cabinet, and the cabinet agreed with us on the value of this young chap. But cabinet felt unhappy about the procedural defects, which they felt were not justified. And the cabinet, you can go to the cabinet resolutions, they will show you that consequences. It's in the resolution of what to call of the cabinet. Now, when I came back, I had no excitement of firing the board. I thought this thing could be done very easily by the board saying, maybe we're enthusiastic, we saw this talented chap, we didn't want to lose him. We want to, but we acknowledge this. When the board responded, you can look at their documents. They never accepted that there was anything wrong. The records are there to demonstrate that. Immediately at that point, I took a view, I'm dealing with difficult people. It is at that point, Chair, then I said, then they must, because it became clear to me, if we cannot find each other on a serious matter like this, how do we then work together going before? Fine, I think about 7 of them resigned. Others were obstinate that there's nothing wrong they did. And then finally, all processes led to me taking a decision that this board must go. Later, we went to the cabinet. We went to the cabinet, made submissions for the appointment of the new board. It was appointed. That's why I've got a little bit of training in law. That's why I don't want to be unethical, and because this case is over now, to say, hey, had you listened to me at that particular point in time? In terms of my understanding of the law, Chair, this is not the board that has been is not an interim board, because it was fully appointed, following particular procedures, submitted a memo to the cabinet. You can go and look at the resolution of the cabinet, not me. The resolution of the cabinet was not appointing an interim board, right? It is against that point that then you had to remove, in terms of the law, you need to remove that board to bring another one back. So, but that's water now under the bridge. Now, against this background, as we were phasing in the new board, the letters from the clients came very strong. I think the most tough one was from Justice, where they were requesting that they be, taken out of the system. And I discovered that there were issues of this client more than 3 or 2 years ago. The records are there to demonstrate that these things were stuck years, not just 1 year. The records are there. I want us to talk about facts, right? So that whatever you do, you look at those facts. Those records are there, right? Fine. So, against that background, it became clear that the issue of clients is urgent. And then my judgment and the advice sitting with the team was that we need an urgent intervention to respond to the issue of the client desperation. And when we did that, the reason was very simple, because I still believe that, Chair, any attempt to close an agency like SETA, is taking a huge security risk with serious consequences. Because no country in the world does not have an agency like this which coordinate IT. Because this is a serious matter. You can either be vulnerable or be safe, depending on, it cannot just be run in a fragmented way. Because if the problem is inefficiency of SETA, you just have to correct that. Now I appointed a task team. This task team was appointed around, I think, December. I just want to read here so that I don't say my words to this issue, Chair. Because I sat with my advisory team and we came to this. In December, against the background of fear of the agency, of clients and their frustration, and by the way, you can look at the law, as a minister, you don't have powers to actually change that mandate because it's a statutory mandate. I just want to read this because what happened is that after I've appointed a task team, they came with a preliminary report. Let me read this. In December 2023, the Minister of Communication, we'll give this to you. The Minister of Communication and Digital Technology appointed ministerial task team to address complaints. To address complaints of procurement backlogs by the State Information Technology, which is SITA, affecting the delivery of information technology service for national and provincial departments. The minister has received numerous complaints from other ministries, from national and provincial departments across the country regarding SITA's failure to fulfill its legislated mandate to provide information technology. SITA's failure to respond to their customers' IT requirements have affected various departments' service delivery obligation to the South Africans. It is worth noting that the MTT started its work in December when most departments and entities, including SITA, were about to close for the festive break. However, the MTT, to get a significant amount of work done during that time, it continued as officials resumed after the holidays. Here is the preliminary report of the MTT, the first preliminary report that was given to me. The MTT has made the following observation with regards to the challenge. That's the team that has been appointed now. You will get the submission on this. One, this is what they discovered. This is in December. SITA's turnaround times in supply chain management are extremely slow, and there's no justification for this. That's point one. There's lack of capacity, both in human bodies and in terms of the required skills to respond to the entity's mandate. Three, the current SITA management has allowed for the procurement department to operate manually. There is no electronic procurement in place to improve efficiency and avoid unnecessary human error. The MTT's view is that this could be deliberate. Tenders are cancelled at the award stage after months of going through the bid process. Unjustifiable excuses such as the wrong bid specification are some of the reasons for cancellation. This reflects SITA's failure to do process market analysis and demand management process before finalizing bid specification. Lack of accountability and no proper reporting structures to client department on the process of their tenders. Clients are made to feel as if they are being done a favor when asking for reports. There is also a general lack of consequence management. There's a lack of transparency, which opens up SITA procurement processes to irregularities committed by officials. This has led to investigation and disciplinary processes against senior officials at procurement level. There's a lack of proactiveness in managing existing contracts, monitoring their performance and expiry dates. There is therefore no proper and proactive planning for the re-advertisement of tenders. This then leads to the extension of contracts, which goes against the constitutional principles of fairness, accountability, transparency, competitiveness in procurement processes. There is no commitment to resolve AG's finding, especially relating to procurement. There is an element of resistance to change and new approach in dealing with procurement matters. The board is limited in terms of intervention. It can make as it can be accused of being operational. The board is limited in terms of interventions. It can make as it can be accused of being operational, and this goes against good governance. However, the current system is designed to block any oversight to ensure proper processes and systems are in place. So, what was the action plan at that time? Facilitation of the appointment of the acting Chief Procurement Officer, recommendation for management to fill in the critical vacancies within the procurement department. SITA management has been urged to conduct skills review and so on. After identifying weaknesses after identifying weaknesses of the acting MD, the board and MTT were of the view that stronger, more experienced external candidates should be considered. The board has since appointed the acting MD. Having identified lack of warm bodies in the current structure to process, prepare specification and evaluate tenders, thus causing a backlog and delays for department. The MTT recommended the urgent appointment of extra SCM capacity for a period of 12 months that will assist in cleaning the backlogs and so on. I can go on. What I'm saying, this is the action in December. But there's a point, so that I go to the end, that I want to share with you quickly, is that I've already explained, for instance, what made that conflict between myself and the board. By the way, this board, what happened is that when the board was clear that we are leading to what to call expulsion, about 7 board members resigned. Of course, the others took fight, which landed us in what to call court. There are 3 board members who remained, simply because when I questioned the directors what informed their decision, and I held them accountable, they gave their background. They shared with me discomfort they had with the majority of the board decision to increase an MD salary. In other words, there was no unanimity in this what to call, in this decision. And you will find that, by the way, when you go to your records, when the MD was given an offer, I hope I'm collecting this chronology, the board had not yet taken a decision to what to call, to finalize this what to call, this thing. Leave all other defects. The facts are there, there's chronology, it's not my fabrication. Now, whilst this board is fired, now emerge this issue of 1.2 billion. It's not coming from the minister, it's coming from Parliament. And we already saw this thing on newspapers, and the Parliament says, do the following. Deal with this. We instructed the board to actually start a process, the one that was appointed by the cabinet. I want to make the board not an interim board. It was appointed by cabinet. That's why I'll explain one day why a board that is appointed by cabinet due process and the resolution is not an interim board. These are some of the things we're going to engage on if the court process, what to call, sort of proceeded. So, now, I asked this board this board took a decision to appoint Cliff Decker, what is it? Yes. And with the findings that were there, and then the directive that was given to the board, now that you've got these findings, implement. So whatever then is said to being reversed is what this board was trying to, what to call, to implement. Whatever is being reversed now is what they were trying to do. The biggest question as a matter of law is that the problem, some of us, Honorable Chair, we don't go around and tell people that we have gone to, we did the crash course in law, the Safunda Pa, because you're not appointed for that. We are appointed as a politician to stick to your lane. But the point is, when an organ of the state take a decision like this Cliff Decker water staff, and this has got the findings it has, the PAJA its directives are very clear. You will either implement the findings or take them to the court to set them or to call aside. Now, in terms of the current records, this board is doing neither of the two. So surely, simply sitting at home in my sofa, they are breaking the law, right? That's why then I made a request. I said it in the portfolio committee last time to the minister that, you know what, because these guys are misgoverning a governance issue, it's important that oversight, I think we've discussed it, I think the minister is looking at that. doesn't matter. We're going to the appellate division. I think I understand what I'm speaking about. We're going to an appellate division, right? That is what we're doing with this issue. Now, we briefed the minister on this issue, where the processes are, where everything is are, and even this 1.2, what to call, 1.2 billion issue. We respected the minister's lack of appetite for taking it, for not wanting to take it forward. If nesixhosa besenza intsomi benza ukuthi yami intsomi ke ngoku iphela apha.
Thank you, DM. DG and DDG Shelembe, there was a request to hear your voice. Please keep your voice very, very short. At the latest, and we still need to provide an opportunity to the board, by 12:30 I need us to break for tea. I don't want to be accused of wasteful expenditure at CETA. So we'll break for tea for 10 minutes and then we'll come back with management. But if you and DDG Shelembe can wrap up in less than 5 minutes so that we may give the board 15 minutes to respond. DG Jordan Gianni. The question on the table is Nenzendo Nina. What have you done, DDG?
Thank you, Chair. The reason why I also asked DDG Shelembe to also join is so that we can be rather quick. Firstly, greetings to the honorable members of Parliament and to you, Chair, and to the board, executive at CETA, and also my fellow colleagues from other government departments. My name is Nonqubela Jordan Gianni, the Director General, and I'm with Mr. uMkhonto Shelembe, DDG, responsible for oversight. Just a very quick one, because we do not want to prolong our response, but the man dealing with oversight and governance will elevate. Chair, in all of this, I think it is correct that ours as a department, obviously, first and foremost, is to ensure the proper oversight with regards to CETA, mainly focusing on the mandate and the delivery of that mandate. And to that extent, Chair, we have been involved as government with regards to then either we call it the repurposing of CETA. There have been quite a number of iterations, and I think I'm not going to, because the next question that may come from Parliament, and there have been obviously previous parliamentary members on it, this has been hindered because of the instability. The instability related to obviously the chairs of boards, and also then the instability with regards to the high turnover of the executive. But maybe just to reiterate what that mandate or that repurposing is. We all know what CETA's mandate is, obviously looking in terms of people, technology, systems, and the interoperability of it. And therefore, there has been a concern with regards to the efficiency with regards to service delivery. Later on this afternoon, you will hear the report from the Public Service Commission, which we participated in. We have been monitoring and tracking CETA with regards to then holding them accountable on their part on the recommendations and the implementations thereof. The second issue related then to cost. As a department, we made then, looking at these particular issues, also taking into account the recommendations from the Public Service Commission, we've made a recommendation with regards to the fact that perhaps part of all of this to really put focus is then to send the procurement issues back to departments. We've been looking into that matter. We agreed in terms of, now and again we agree on the threshold. As we agree on the threshold, a board is changed. The implementation and execution of it, the next board wants to come back and restart the process and to review it, and the process starts all over again. You make progress with, because the board perhaps has been in for 8, 9 months, and then again the board is moved, and then we have to then again restart the process. I do believe that it is one of the tedious issues that if you actually remove issues of procurement, or alternatively, which was another proposal that came from a SITA board, was then to say, one, let's create a dashboard. I think the Deputy Prime Minister omitted to say part of the MTT task. Create a dashboard so that even the government departments will have a full line of sight of how they can track and where the request is within the system. The second issue, which has been long outstanding, has been the e-procurement systems as well. And again, that was also then intentional to say that will actually provide full transparency with regards to the process. SITA came up with a proposal with regards to a marketplace. A marketplace, again, even makes it more in terms of us. I think one of the honorable members raised the issue to say you are supposed to be leading the country on digital transformation. And therefore, if you look at a marketplace, it's all, everyone able to participate. You basically have a much wider view, as well as the participation from the sector, from industry, in terms of solutions that you can provide. And what was genius about that particular proposal is that there is a level of the control from the client perspective, provided then, as I said, SITA will be responsible for the norms, the standards, ensuring interoperability, testing the issues related to your cybersecurity, etc. Now, the question that arose, Chair, has been that we've noted as a department, when there are challenges either from clients, departments, or coming from FORSAD, which is the Forum of Director Generals, or coming from Parliament, we do escalate those to SITA. At my level, it's a correspondence, obviously, to the accounting person at SITA, which is then either the MD or someone acting. In this instance, for this particular one, the previous portfolio committee chair wrote to then minister to then raise to say there was a query with regards to a particular tender. That was also sent to SITA. Twice a correspondence was made around May, and then again, because I keep on saying changes, and we had to resubmit again to then the new board. Subsequently thereafter, we all know there was a forensic that was done. It was then finalized, and the outcomes of which were then being implemented. Then the issue, just want to indicate now that because of governance issues, there is always a disjuncture with regards to at what level can we interact with boards. But we were taking the opportunity to say, if you establish units or committees within boards related to the function or issues that are being escalated, the board needs to have a line of sight and not necessarily wait a quarter for a response level. But I think that matter is still being dealt with within how then we can address the issues with regards to correspondence, etc. I think the ministers and the DM have have indicated what we do in terms of the from the department perspective. When we do make a submission, we make a recommendation. We have noted, and I must indicate this is an exceptional circumstance. We have never come across this level of instability and chaos within the period. As I said, I'm happy with Honorable Botland, personally for me, where it's been acting and what have you not. And I'm also want to put it on record, Chair, that some of the submissions that have been said this morning, they have not been escalated to us. And I think the minister and previous ministers have always said, take us into confidence. But they are not coming through. And it is unfortunate that a platform public like this is where we all learning. And the last correspondence with the minister, similar, it reflects that, to say, give us time. Because after we had your session, even the first one, we had to write to the board to ask for information. Now, we write, and that would have been an opportunity to get all this information. We wrote, we received the clearly substantive information, but not everything. Now we come to another forum, and we're now faced with now additional information, and yet an opportunity was array. I'm not so sure at this level. I think, as I said, I need to sit with legal, because clearly there should be a process in terms of the level, or as we advise the minister and the DM, the level of accountability and holding a board accountable in the proper processes and structures, and not for all of us, and then we're now being held in terms of being reactive. With your permission, Chair, I'd like just the DDG to touch on the governance issues. Thank you.
Ngizokhawuleza, Chair. Good afternoon to you, Honorable Chair, honorable members of the Portfolio Committee. Good afternoon to the Minister, the Deputy Minister, the Chair of the Board of SETA, and the board members and everyone present. Chair, I think the DG has really touched on the relationship between ourselves and SETA. But I think I'm just going to try and explain the constraints within the oversight environment that we operate in. You know, I remember when we were doing the PFMA, I was at Treasury at the time, and the mantra was that let boards or accounting authorities govern entities, and let managers manage. That essentially meant that the accounting authorities will take the full responsibility for accounting for that entity, and that the shareholder minister or the executive authority will perform an arm's length oversight to that entity. That is the same oversight model that we still use now. So that model essentially then means that what gets to us is what is escalated by the board. We do not sit in the board meetings to know these squabbles that we are now learning about today. We do not sit there, and the boards typically, and SETA in particular, has not escalated these things to say, Minister, we're having a dysfunctional board, we need your assistance or your intervention. So that is the nature of the governance framework that we operate under. In terms of Schedule 2 and 3B entities, that will be your major public entities, government as a shareholder is required to enter into a shareholder compact with that entity. But SETA is a Schedule 3A entity, so there is no legal requirement to enter into a compact. But that notwithstanding, we have developed what we call a governance agreement that the minister enters into every year with the entity. That governance agreement provides for the responsibilities for the minister towards the entity, as well as the responsibility of the board with respect to the performance of the entity in terms of its target and performance or predetermined objectives, as well as proper governance of the entity. Through that governance agreement, we have provided for a whole host of submissions that we may demand from the entity when things go pear-shaped. And we do request entities to submit certain reports in that regard. One of the reports that we request from entities to submit is a board evaluation report that is required every year to be submitted. But we have had difficulty to get this evaluation report from SETA because of these changes that have been taking place between boards and their inability to appoint a service provider to assist them to perform that board evaluation. So we would have picked up again these board dynamics from that board evaluation report if it had been submitted to us, but it has not been submitted to us to date. So
I want to stop you, DD Shalem. I think we're going to have to unpack this a lot more because it speaks to the linkages between the department and SETA, which we have not yet interrogated. So I want to stop you. I hear you. Ne? So thank you very much. We'll come back to that. Chairperson Musidi? Yes, sir.
Chair, just an intervention. I think with the new information that we have now, I want to propose that we proceed differently. Firstly, we didn't know when we came here that there was now a settlement signed, that they're just finalizing the details. Now, with that information, I think that should inform our way forward. Firstly, if we have a settlement, and I think it's a good thing, we congratulate the minister for having arrived at that. If we have a settlement, then the deal is done. So then we must move from there. We've got a settlement now, all the warring forces and all of that. I don't see the point of the board responding here. I really don't see the point. They've made their representation. The minister, the former minister has also said, the court has pronounced. We are now moving from that process. So for the board to be saying, no, the minister is wrong, and this, it's not going to help anything. I think we've reached a settlement now. Let's see the settlement through. And the next thing that is left now is the minister can invoke Section 63 of the PFMA, where he can exercise executive authority, like he should, the ownership authority. The law gives him that. And in terms of that, what the minister can do, two options. He must firstly put some interim measure of sorts. One, you could either find somebody external, if you like, it's all up to you. Somebody external to take the role in the interim whilst you're busy with your adverts and things, or you can ask the audit committee to do that oversight role. You can decide which way you want to go. I really don't want us to sit here and pretend that we are running an inquiry and listening to all kinds of submissions and critiquing who said what and all of that. I don't see where that is going to take us. And then lastly, I would ask the minister to share with the committee the advert. And I think what I want to check within the advert is what is it that the minister is looking for, because there's always this danger with these adverts that we actually attract technocrats at board level when we're looking for leadership at board level. This is a problem. You just invite a conflict, as it were. So we would want to interrogate that and make sure that this advert, you're not going to find people here that are going to be competing with executives in terms of the core business of this organization. We're looking for people to lead, not people to operate, as it was. So I would like, I think as this committee to see the advert, yeah. So that's it, Chair. I just don't see why we should be turning this into an inquiry.
Thank you very much, Honorable Manye. I'm not sure how to proceed. One, because what I understood, Mr. Tsotsi, a lawyer, mbona nje mayikhuluma ukuthi ayitsotsi. Yeah, what I understood Tsukhufatso to be saying is that you are in the process of finalizing the settlement agreement. Amongst yourselves, you are finding one another on the issues being the legal fees as well as the amount to be paid. But Honorable Manye, the settlement agreement then speaks to closing of the matter, but the board is still in office. Up until, am I correct, up until January 2025. Now, when the minister was responding, the minister says, one, he can consider the proposals that are being put on the table. One, which is what you have now spoken to right now on Section 63 of the PFMA, where he can take a decision to dissolve the board and put in an interim measure because he does not want a leadership vacuum. Alternatively, he has an option to allow them to complete the term, but then he does not know how much damage there would have been in the interim. That's how I understood it. Then he says he's applying his mind to ensure that whatever decision he takes is as procedural as possible, but that he's able to bring stability to the organization. Uyotsho minister if misrepresent. So, given the fact that we are awaiting the minister and the settlement agreement only speaks to end of January, when it will be implemented, I think that we still have this board before us now. Honorable Manyi. So I would want the chair to speak to issues, because even if a decision was taken by the minister either way, there are things that I think we still need responses to that have been raised by the members. Thank you, but I'm not discounting, Honorable Manyi, the issue that you and several members raised that said, if Begamba Ogwetu, we would want the minister to take a decision on this matter, even during this process. Thank you, ma'am.
I have one. Thank you. Chair, there were a lot of questions, and I'm aware that I have 5 minutes. So most of the operational questions, I'm hoping that EXCO will have the opportunity to respond. If in any way you might be thinking that we are operational. We are 2 months back into the job, exactly 2 months. And if people are talking about operational temperance and so on, I think perhaps it is a little bit misplaced because we have just met once. However, I do take the point that I think as a board, the problems that we're having, I think, and because we're a hybrid board, that can also find itself in the current board. But I think it's not necessarily the board that has been reinstated. And the second one that I just want to respond to is the CDH report. Because I think this one is quite important for me because it speaks to how we have operated, how it has evolved, and how it's going to impact other people. The report was concluded in October 2023, according to the previous board. If it was so urgent, why would it wait until now in September when we come back, 2024? If it was really a dire situation where the board needed now to tell the SIU, they could have done it in November last year. Why is it happening now? And perhaps that's the question you should ask, because that particular tender, the request, Honorable DM, to actually investigate, it came to us first. So by the time we were dismissed, we had it already. So we were beginning to do that. So there's a bit of a, and I don't want to do an us and them, but I'm just saying, because this is a public platform, what is incorrect we'll have to correct. And we cannot just leave it hanging whilst it's actually not right. The CDH report was concluded in October 2023. It only started moving now when we were reinstated. Perhaps that's the question to actually ask. The rest of the questions, Chair, if there is still something that maybe EXCO will not respond to, I'm prepared to respond to all of them, especially because it is a public forum. I'll stop there for the sake of your time. And I mean, you have a lot of questions, strategy and all that, all these things we have. Thank you.
Thank you, Chairperson. I'm going to ask that we break. Let's break for 10 minutes. Except to say, Chairperson, there's a number. Minister, there's obviously a number of recommendations that have come from the Portfolio Committee. While we are going to what we want as an outcome for this will obviously be communicated to the minister in terms of the report that we will write. Safe to say that coming from the Portfolio Committee, it's very clear that we don't think that we've got the latitude of time in dealing with these matters. So I know that you do have to go, and perhaps during this break, because Benteni funwa lunch. So maybe, but you are welcome to stay. I would like you to stay for the presentation of the executive, if possible. Let's break for 10 minutes, and then we will reconvene at exactly 1:45.